Hello and welcome. In a few hours from now, the Delhi High Court will be hearing the ongoing case on petitions challenging the legal exception that protects men from criminal prosecution in cases of forced, non-consensual intercourse with their wives. Basically, there are multiple petitions challenging the exception to Section 375 of the Indian Penal Code, which exempts forceful sexual intercourse by a man with his wife from the offence of rape, provided that the wife is above 15 years of age. Now, the Delhi High Court is currently in the process of hearing final arguments in a series of public interest litigations or PILs challenging this marital rape exception clause in Section 375 of the Indian Penal Code. Now, Section 375 of the IPC defines various acts that, if done against a woman's consent, by force, by fraud or coercion, or to a woman who is incapable of giving consent, these are defined as rape. Now, the heart of the debate right now is an exception, Exception 2 to Section 375 of the IPC, which states that any sexual act performed by a man on his own wife is not rape as long as the wife is not a minor. So, we're asking, does marriage mean irrevocable inherent consent? Do women not have a right to their bodies after marriage? Are a husband and a wife not equal before the law? These are all disconcerting questions, but they must be asked. They must be talked about because it exposes perhaps, a deep-rooted patriarchy in our society. It raises questions about the concept of marriage in the Indian scenario. And apart from the legal complexities, there are social and emotional impacts of this. And we at We the People don't shy away from difficult conversations, and so joining us tonight as we turn a mirror on ourselves as a society, we have Satyapal Jain, Additional Solicitor General of India, member of the BJP, Pinky Anand, also with the BJP, a senior advocate, former Additional Solicitor General of India. We have Vrinda Grover, Geeta Luthra, both senior advocates in the Supreme Court. Rupenshu Pratap Singh, a men's rights activist and an advocate in the Supreme Court and the Delhi High Court, and Seema Samriddhi Kushwaha, an advocate again in the Supreme Court and also Nirbhaya's lawyer. So, I guess I want to start with our, women lawyers. The most important question perhaps before the court is, how do you define consent? So, Vrinda Grover, to you, not an easy question. There is an expectation of conjugal sexual relationships in a marriage. But does this mean a partner has a right to sex? The social construct of marriage implies you have an emotional and a physical or a sexual companionship. But does that mean consent is inherent? If someone is married, does a partner have a right to say no legally?
So, there is a mutual expectation of conjugal sexual relationship in a marriage. It's not just from the man. Secondly, the expectation may well be there, and that is part of a marital relationship. I think the question that the court is addressing, and the only question that a court of law can adjudicate, particularly a constitutional court, is whether that expectation, when it transgresses and encroaches the fundamental rights of a woman, can that continue to be allowed within our current constitutional jurisprudence? And therefore, what is important to also recognize, what is the legislative history of this provision, which comes from a colonial era. And we know that the present government has repeatedly said that colonial laws will have no place in independent India. Well, here is a provision which continues to perpetuate a man's conjugal rights, in fact, his privilege and his control and dominion over a woman's body, which is today in absolute conflict with our constitutional rights as guaranteed under the Indian Constitution and elaborated in the from the Puttaswamy judgment onwards, where privacy was recognized as a fundamental right, as well as the autonomy, agency, and control that a woman must have over her own body. And this has been in great detail explicated in a 2019 judgment of the Constitution Bench of the Supreme Court called Joseph Shine, which decriminalized adultery on precisely these grounds, saying that constitutional morality must enter, and there may be social morality. There may be people who do not agree. But when a constitutional court is going to adjudicate, it has to see what are the guarantees and rights that a woman enjoys. And if this legal immunity, it actually gives legal immunity to a husband because it in perpetuity recognizes that consent is given, or in fact, actually where it comes from is that a woman has no say in the matter. She has no agency. And that has been struck down by the Supreme Court. So I don't think this exception can withstand judicial scrutiny any longer.
So does a woman have no agency or have no options? Pinky Anand, in court, those who oppose this move say that women who are subjected to sexual violence by their husbands, they're saying that, you don't need to do all this. You don't need to change this IPC. This option is not necessary because women do have other criminal avenues available to them to protect them today. What would you say?
This is quite an ignominy, so to say. You can't say you have other avenues, therefore you shouldn't have a particular avenue which is available. The question today is, considering 375 IPC, considering that IPC itself carved out exception initially for even younger children between 15 to 18 in terms of statutory rape. Similarly, exception 2 carves out this exception for marital rape, and this has stood over the period of time. Of course, when that's right, it comes from colonial era. In fact, starting from somebody called Chief Justice Matthew Hale, right back in 18th century, and today we are somewhere in the 22nd century. So I don't know what we are really talking about on that. But the question is of having other revenues like avenues, like you're talking about 498A, or you're talking about divorce. In fact, recently, I think the Karnataka High Court also granted a decree of divorce on the ground of marital rape. But the point is not that. Today, the whole question is the law in our country says there is rape if there is absence of consent.
Yeah.
And if an unmarried woman is raped, the same will amount to rape. And if it is converted into a marriage, it will stop being rape. I mean, that is a real question today that does stand. Is the classification on the basis of rape, which can withstand the scrutiny of law. And frankly, I'll tell you, the whole question really, which has arisen today, we are talking about the penal code, which has been there from the 19th century in India. We follow colonial era. We go into various laws which treat women as a property of the husband.
And England has changed these laws.
England has changed, Pakistan has changed. I mean, you have more than 100 countries that recognize marital rape as an offense. The question is not whether a person should file or not file. The question is, can a person file? Should a person have an access? Should a woman have an access to say, I cannot be forced upon or I can't be considered the property? Should the question of consent be implied when consent itself cannot be implied? If it is a no, should it mean a no? Or is it something which can be transgressed on the ground of it there being an exception to 375 IPC? I think these are all the crucial questions that have come up. And for example, even today, as it stands, you have 377 as an offense for a married woman or even as on date. So unnatural offense would still be constituted as an offense under the IPC, whereas marital rape is exempted. So I think the whole perception is starting from this whole concept. One understands where it comes from, not that you don't. There's the whole question of institution of marriage and the fact that there was this balloon made and said this is carved out and nobody will go into this balloon and will remain intact. The balloon has had to break it at an appropriate stage. You have a civil society concept. You have something which doesn't stand withstand the scrutiny of Articles 14, 15 and 21 of the Constitution. It can't. The question has now come to court, has been there for some time. Justice Verma's committee, for example, also recommended. Justice Malimat committee went into the question.
Yeah.
You've had every possible recommendation. Anyway, the point is, can it be done? Should it be done? I guess we all agree that the time is right for this action to be taken. Even the government is undertaking a consultative process. Unlike there has been a change in the affidavit to that extent, this consultative process will hopefully result in a changeover. In any case, the matter is before the court. And the courts have to take into account whether this is constitutional or it is unconstitutional.
But we've taken our time. It's been, I think there's been a break because of the pandemic, and more important issues were being discussed as the government had to prioritize and our courts had to prioritize on cases. But Geeta Luthra, if you can pick up on what that important point Pinky was making over there, Pinky Anand, that we have this odd situation that where under the current laws, so an unmarried woman can prosecute a man for sexual intercourse, maybe her partner, her long-time partner, her live-in partner, while a married woman cannot. So we're basically discriminating against married women in a sense?
Yes, so in a sense, you are really continuing the argument of Joseph Shine. You are really continuing an argument where adultery was an offense because you said that a woman was a man's property. So if another man had sexual relations with her, then he was guilty of adultery. So similarly, the actual original concept was that a woman was being treated as an extension of the man or the man's property. But so therefore, if we look only from Joseph Shine viewpoint and what the law laid down there, then it's bound to be struck down. But there is a very important question which the court is asking, and which is the question we have to ask ourselves. Can the court legislate? Would it be a new offense in the Indian Penal Code? Would this be indirectly legislating, and is that going to be a reason why the court may be shy of interfering? Because what the question the court has put to the petitioners is this: tell us cases where offenses have been added by the courts in the penal code. Now, the arguments that have been made by all petitioners, and which is a very attractive argument, but may be difficult to answer this question, is this: that we are only saying strike down this exception because it falls foul of Article 14, 15 or the dignity of a woman. And since this is in its own way an exception, if you strike down this exception, you make a married woman equal to an unmarried woman, equal to a live-in partner, equal. But again, the courts have only asked this question, to which the answer can perhaps be the law. As Pinky said, in 1991, House of Lords said the same thing which had been said, say, in 1876 earlier, and which was turned down and turned around. And the House of Lords says in R versus R in the UK that, look, we cannot but not accept this argument. It was a case of attempt to rape, and the wife was making this allegation. And the court said such an argument in today's day, when men and women are equal, cannot be made. But then the devil's advocate may say, should men have the same right?
True. Interesting. Yeah, should men have the same right? I'll go across to that, but you know, Pinky, Pinky says that the centre's stand has changed on this matter, but in a sense, really, they've been very unclear and wishy-washy. 2016, first they raised issues of social disharmony, damage to marriage and family systems if marital rape is decriminalized. Now, in its latest affidavit this week, they have taken the stand that you've talked about, that they're saying you need more consultation on this contentious issue. I really do feel we'd like to get a clear idea of where the government stands on this matter. But the other issue raised over here is, you know, men. We're hearing arguments in this case also from men's rights organizations that are opposed to this petition. And Rupenshu Pratap Singh is he describes himself as a men's rights activist. He's also an advocate in the Supreme Court and the Delhi High Court. And Rupenshu, you're part of this group that's supposedly trending on Twitter called #MarriageStrike, where netizens are vowing not to marry if marital rape is criminalized. We have pictures of men holding placards saying, "Save Indian men." Basically, your fear is that this would be misused, like many other laws in this country.
It's not about the misuse of this thing. The marital bond is of a private nature, and it is essential to maintain the privacy between the husband and wife. Since marital privacy is an extension to right to privacy, therefore it forms an integral part of Article 21 of Constitution of India. And if we also talk about the equality, then Article 14 gives us something where you are equal in a similar manner. So if we are just bringing down the exceptions in section in 375, then we require to change some more sections as well, because specifically if you are not seeing the status of a married woman versus unmarried woman, because like married woman can file section 125 CRPC case on a spouse, so not likely an unmarried woman. So the status changed after the marriage. Similarly, like section 114A of evidence talks about the consent. So whatever incident are taking place is within the four walls, and there was only two persons present. And this is a very sacramental thing. Like this marriage in India is a social religious sacramental union, not only between two individuals but between two families. And it is evident since times immemorial that the purpose of marriage is not confined only to the physical intimacy of the partners, but goes far beyond and is indispensable for the growth of society by way of procreation of urgency.
Okay.
And one more small point I want to discuss here, that right now after the Arnesh Kumar judgment of Supreme Court, they have given 41 CRPC gives where the punishment is lesser than 7 years, then you have to give an notice to the person to appear. But in case this 375 of marital rape comes into the picture, then the automatic arrest will take place. So what would be the self-dignity? And if you are talking about the husbands on a manner, what if comes out that the accusations led by the person is false, but if he already gone behind the bars, then what would be his future, his self-dignity, how society will treat him? And what about his kids? How his kids will see him?
And what will be her future? Okay, I'm going to raise that with Vrinda Grover. But first, Seema Smriti Kushwaha, could you respond here to Rupenshu Singh about the misuse of laws and the rest of his points? Because many laws are misused.
अगर हम 18th सेंचुरी की बात करें, जब हमारा देश आजाद नहीं हुआ, तो जो भी ब्रिटिश पीरियड में लॉज बने वो अभी तक इंडिया में उनको ही फॉलो किया जा रहा था. जब एक प्रोग्रेसिव लॉ की बात आई जहां पर विमेन के ह्यूमन राइट एंड उसके जब फंडामेंटल राइट की बात हुई, आर्टिकल 21, आर्टिकल 19, आर्टिकल 14 की बात हुई, तो वहां पर अगर देखेंगे कि सोसाइटी में अगर आज भी 498 एक केसेस देखेंगे, 377 आईपीसी की बात करेंगे तो 377 अननेचुरल सेक्स की बात कर रहा है. वो ग्राउंड डिवोर्स का हो सकता है, बट वो रेप का ग्राउंड नहीं है. अगर मैरिटल स्टेटस में रहते हुए एक फीमेल अगर अपने हस्बैंड के अगेंस्ट ये एफआईआर लॉन्च करवा रही है, अगर मैम हम पूरे स्ट्रक्चर की बात करें, क्या एक सोसाइटी में फैमिली जैसे इंस्टीट्यूशंस को प्रोटेक्ट करने के लिए इंडिविजुअल विमेन का राइट, उसका फंडामेंटल राइट, उसका ह्यूमन राइट का वायलेशन होता रहेगा? दूसरा, अगर हम पूरे स्ट्रक्चर की बात करें मैम, चाहे वो कानून जितना भी अभी तक मेकिंग हुए हैं, इनकी पॉलिसी मेकिंग की बात करें या फिर पूरे स्ट्रक्चर की बात करें, चाहे हमारा रिलीजियस स्ट्रक्चर हो या हमारा एडमिनिस्ट्रेटिव स्ट्रक्चर हो, पॉलिटिकल स्ट्रक्चर हो, सभी में सारा चीज तो मेल पर्सन के द्वारा ये क्रिएट किया गया, सारा उनके द्वारा बनाया गया. अगर एक फीमेल जिसका अगर प्राइवेट स्पेस की बात हो रही है या प्राइवेसी की बात हो रही है, तो उस प्राइवेसी से निकल करके 498 एक के केसेस है वो फीमेल कर रही है, 377 की केसेस कर रही है. वहां पर सबसे बड़ा जो रोल है लॉ के, अगर मिसयूज की बात होगी तो सबसे बड़ा जो लॉ का रोल, जो इन्वेस्टिगेशन एजेंसियां हैं उनका रोल प्ले करना आएगा कि जो इन्वेस्टिगेशन एजेंसियां किस तरीके से इन्वेस्टिगेट कर रही हैं कि अगर फॉल्स केसेस हो रहे हैं तो उनको कैसे रोका जाए. ये लेजिस्लेचर का काम है, ये इन्वेस्टिगेशन एजेंसियों का काम है. लेकिन इस वजह से कि लॉ का मिसयूज होगा, किसी एक इंडिविजुअल इंसान की आइडेंटिटी, डिग्निटी को आप इंस्टीट्यूशन, फैमिली इंस्टीट्यूशंस के नाम पे डिस्ट्रॉय किया जाता रहेगा। तो ये तो मुझे लगता है कि एक तरीके से जो भी मेल पर्सन आकर के स्ट्राइक करे कि इंस्टीट्यूशंस को बचाना है, या इंडिविजुअल फीमेल 49% आबादी जो कि एनर्जेटिक है, टैलेंटेड है, जो कि अपने राइट का यूज करना चाह रही, बट फैमिली जैसे इंस्टीट्यूशंस में,
fair enough, yeah, all important points.
Yes.
Vrinda Grover, we're talking about protecting women. So, in a sense, there's another difficult aspect to this whole debate is that, rape is a serious offense and it carries a long jail term, 10 years. So, the thing is, if someone rapes you on the street or commits a crime, you don't care if they go to jail. In fact, you want them put away. But when you're married, the reality is when you're married, when you have children, you're financially intertwined. A woman will become destitute if her husband is charged with rape, put away perhaps for 10 years. So, what do you advise your clients, Vrinda Grover, Pinky Anand, when they come to you, that because does your client want to send their husband to jail, or do they just want the violence or, the mental stress to stop? How do you balance that as someone who speaks up for women's issues, women's rights, and as a lawyer protecting your client's long-term interests?
So as a lawyer,
I'm afraid if you're asking what should a lawyer be doing or what we should be doing as lawyers, I would say that this really depends upon what the woman wants to do. It will be very difficult to really advise a woman that you should file a complaint or you shouldn't file a complaint. In fact, it is my general belief that in matters particularly of such emotional issues and of tangible kind of relationships that you have, what should a woman do? Should she seek a remedy or not seek a remedy? Is purely up to her. It is very difficult to say that a lawyer should actually intervene to say you should, because the consequences, as you rightly said, are something that she's got to decide for herself.
But Vrinda, if the law changes, then where does this leave your client?
To that, if I can, I think as Pinky has very rightly said, the job of a lawyer is to advise, and the job of a lawyer is to lay down all the legal options before the client. Each woman, and that is where we also need to respect the agency of the woman, she takes a decision depending on her circumstances. The Protection of Women from Domestic Violence Act of 2015, in the definition of domestic violence, includes sexual abuse. So there is a civil law remedy where you can get a protection order from a court of a restraint of an injunction, including against sexual abuse. What is not available is, and again, it depends on the circumstances. Perhaps the protection order, a civil law remedy is not enough for what she wishes to go ahead with. And therefore, the criminal law remedy will also be available, and women will decide and choose which avenue of law, a wife will decide and choose which avenue of law she wishes to access. So it is not as though the civil law remedy is not available and that she will not know what to do. What is happening today is that the other remedy places marriage on a pedestal and subordinates the woman, particularly her self-determination over her sexual relations. I just want to add one more point, if I may. The issue that was raised about a new offense. This issue was frontally addressed by the Supreme Court in independent thought, which raised the age of, where earlier it was if the wife is below 15 years, raised it to 18 years. In independent thought, it was categorically said by the Supreme Court that we are not creating a new offense by doing this. Here also, what will a deletion of the exception do? The immunity to a subsection of men, namely husbands, will be taken away. The offense, as in Section 375, stays and stands as the same offense. There is nothing changing in the offense at all. No new offense gets created through this.
All right. All right. Well, this is not the last we've heard on this, but as Pinky Anand pointed out, marital rape has been criminalized in more than 100 countries. But India is in a league of our own with a small club of countries, about 32, where marital rape is not criminalized. And we're bracketed along with the lines of Afghanistan, Iran, Nigeria, Libya. Even the English, like we said themselves, criminalized marital rape way back in 1991. But now it remains to be seen how the court will interpret all of these legal issues, intricate legal issues, aspects to this that have been raised by everyone on our panel tonight. Thank you all for joining us, for being part of this conversation, for putting the spotlight on this. Thank you. Bye-bye.